exhibit that the plaintiff has put in, but I've divided it into two packets because the defense position is that there are morning photos and there are afternoon photos. And so they merged them all together and mixed them up. So I divided them up. So I would like to admit 3401.
Is this on this list?
It should be on the list. It is on the list. It's the last exhibit. I'm sorry, to put it in order, there's 3400. And I've given a hard copy of this to the Plaintiff's Counsel, 1 through 14.
We object, but I'll wait.
And 3401, 1 through 9.
Okay, and so just tell me what these are before we look at
Sure.
them.
Here's the deal, Judge. They put all these photos, they're already in evidence, all of these photos. They mixed them all together. You can tell by looking at them, in some of the photos she's in blue shorts, and some of the other photos she's in pink shorts. They merged them all together, they're all mixed up.
Is this the before and after court?
Correct, Your Honor. So I divided them up by before and after court, and I want to use them in that fashion with the witness, because otherwise it's totally confusing for me to be able to use the exhibit. It's the same exhibit, simply divided into morning and afternoon.
So all of these exhibits are already in.
That's correct, Your Honor.
And it's just a reorganization and putting them. So what's the issue, Mr. Whitney?
Your Honor, first of all, they're already in. They can make the argument about blue shorts or pink shorts without putting this photographs into evidence twice. Secondly, what they've labeled as 3400, you'll notice, is not bait stamped. 3401 is. So the accusation that we mix these all up, we don't know the progeny of 3400 since there's no bait stamp on those.
Well, how about 3400-2? Are there any bait stamps?
There's no bait stamp on. I just looked at all of them. Anywhere in 3400, there are no bait stamps.
Judge,
And we must say, Judge, that our information...
Can we go back to just one
Yeah.
lawyer per subject?
Yes, sir.
Thank you.
Judge, I don't recall if their exhibit has bait stamps on them, but we can put the bait stamp on there if that's the issue.
Were the ones that came into evidence already, did they have bait stamps?
I don't recall, Your Honor. I don't know if they just had exhibit numbers, if they had bait stamps. Perhaps counsel can
They
enlighten
did,
us.
Your Honor. Ours had bait stamps, and
Can you give me just tell me the exhibit number that's in evidence and pull it up real quick?
it looks like 2604-006, 2604-001.
Let's just pull up the first one.
Yeah. 2604-006. 2604-001.
Yeah, those are on.
And you'll see these have bait stamps.
Well, Judge, we can put the bait stamp back on if that's truly an issue. I mean, there's no question they're the same photos.
And all I'm seeing here are 3 photographs. I don't know if I'm sorry. Oh, they're not here in front of me. Okay. They all have bait stamps. We introduced them in the way they were produced to us. So the mixing up of order is not the blame doesn't go to us for that. This is the way the hospital produced them with bait stamps. We put them all in evidence. They can make their argument about blue shorts or pink shorts. There's a factual dispute about whether there were before and after photos. Of course, they take the position there were. Maya Kowalski says it happened one time. Kathy Beatty forced her in a dress in front of her and changed her before court. That's a factual issue that they can take up with the photos that are already in evidence.
Judge, we'll be happy to put the bait stamp numbers on. I think probably got deleted when we put the new exhibit number on. Happy to put the same bait number now so they can do a comparative analysis. They're clearly the same photos. It would be... I do not want... I think the defense has the right to have the jury see these as 2 separate packets, one before and one after, as opposed to getting them all mixed up when they're back there in the jury room.
The other point I need to
clearly,
make-
I'm sorry.
Go ahead, Ms. Quarles, you can finish.
Sorry.
These are clearly in our view, and the testimony will be 2 separate photo sessions.
The other point I need to make is there's no date and timestamp to confirm that. So what's the point of putting them in this fashion? They're already in evidence. They can make their argument. If they were timestamped and dated differently, if one was a morning set and one was an afternoon set, from the face of them, perhaps. But that's not the case.
I think at this point, Ms. Quarles, if these photos are already in, let's just go with what's already in. I don't want to, if Mr. Whitney is correct that these were produced in a different fashion and not as a coherent set, I don't want to be seen as glossing a coherent set. If they're already in evidence, let's just go with them as in evidence.
Okay.
Next issue.
Just as a matter of scheduling, the court had told the plaintiff yesterday when we tried to publish emails, whether we could just publish them or need to publish them through a witness since we're running out of trial days. The court asked the plaintiff to make a commitment this morning. So we would like to hear from the plaintiff whether they would require us to call a witness to publish or if we could just start publishing.
Anything further on?
I'm sorry, I wasn't paying attention. We were not allowed to do so, Judge. We had to put ours in context with a witness, was the court's ruling. We do not believe that it's appropriate nor particularly time efficient to stop the testimony to simply have the jury stare at the screen for a minute on each one of these. So we would object to just simply having them put in without a witness, any context or anything else.
Did I allow the plaintiffs to publish without a witness? And I'm not talking about a situation where we had a deposition and then published exhibits that occurred in the deposition, but did I allow plaintiffs to do this?
I did not. During the course of what I was doing, unless Mr. Whitney remembers differently, during the course of what I was doing, we did not have that, and we actually asked for it within the first week to be able to put some of the documents into evidence before we had a witness up. We were not allowed to do that. The court wanted it to be in context with a witness if we're going to bring them in, and it's a waste of time here to just have the jury stare at these. I mean, at least have some context.
The court did allow them to publish, for example, policies and procedures of the hospital without calling a witness. In terms of efficiency,
Was that in relationship to a deposition, or did I just?
I believe, my sincere recollection is you just let them publish. In terms of efficiency, this can be far more efficient of the court's time for us to just publish, let them read, than for me to call a witness and walk them through. But if they're going to require me to recall an expert or require me to call somebody like Dr. Rich Elliott as a teammate.
Here's my thought.
Yeah.
I don't want to just force people to spend money to publish a document that's in evidence. I think at the bottom line that is wasteful of everyone's time, money, and energy. But I don't want to spend time publishing 30 emails. So, if you can do a handful and then perhaps get some others through a witness.
Yeah.
Obviously, I will keep your time running during any publishing that you do, but I will allow you to do a couple of them without a witness.
Okay, so we will likely publish maybe 3 today. Okay, thank you, Your Honor.
What's next?
Judge, I guess now, unless the defendants have found something overnight, we still do not have the 2017 review of Kathy Beatty, which would be the one that encompasses the actions of the fall of 2016. And we need to know, once and for all on the record, whether that exists or not. And if it doesn't exist, then we may need to recall the defendant's expert on that point, because his opinions, the court may recall, included a review that apparently does not exist. So they found it?
I believe we did inform council last night, but I double checked with my client's HR department, and the last review for that period ran through October 27th, 2016, which is the one that they were handed. Because they changed over systems, the next review did not start until July 1st, 2017, after the incident in question, 2018. Yeah, there's no written review after 10/27, so there is none to provide for the second part. Yes.
So there's no review of employees by the hospital? I mean, that's what I'm hearing you say.
There's no written review of this employee between 10/27/16 and 7/1/17 when the next.
Are there written reviews of other employees?
I'd have to double check that, Your Honor.
Can I add, Judge, my understanding, in speaking with the hospital, that they had a changeover in system. And because of that, there were no reviews done in October of 2017. They were done in October. In October of 2017, there isn't one. It's not until later that there's one. But I think the point, Judge, is the witness was testifying based on a document that ended in October of 2016. To the extent that the jury or the court or the other counsel is concerned that they were given the impression that there was a review he reviewed after that, we're willing to stipulate to a statement being read to the jury that says the review that was testified to by Mr.
Anderson.
Thank you, that's right, Anderson. Mr. Anderson was a review that ended in October of 2016. He did not review anything post-October 2016.
Well, it seems hard to believe that an organization did not conduct reviews. How did the hospital make decisions on whether to give an employee a raise or not a raise? I mean, it would seem to me that an organization would not go more than a year without giving employees raises based on some sort of review. And I know of no organization that is of a large, that doesn't keep written documents of performance of it. Maybe small companies where the owner knows everybody, but
I hear you, Judge. My understanding, but we're going to double check. My understanding from talking to the people back there that do this is that because of some big, huge change, the reviews were all postponed and there was no review done and written performance evaluation, such as what was done before in October of 2017. But let us get clarity on that issue.
when was the next written review? And I'm not just talking about Ms. Beatty, I'm talking about for everybody at the hospital.
We only focused on Ms. Beatty, so let us re-ask with that broader question in mind.
And the question of how did they give raise determinations if you don't have reviews? I mean,
let us clarify that, please.
who's going to speak on this?
Yes, motion to strike the testimony of Mark Anderson to the extent that it involves opinions that where he based it in part on the 2017 review and/or a jury instruction to that extent in the event that there is not a satisfactory explanation for what that's.
I want to get more information before we decide what we're going to do.
Yes, sir.
And we will do that, Judge.
And just to let you know, you might need to have an HR person come and talk about this, and that might have to be done on short notice, so get somebody on warm standby.
We understand.
Anything else before we bring in the jury?
The only thing I want to say on that, Your Honor, is in regards to the record, we had given defense counsel notice last night that we wanted to recall witness Mr. Anderson, however this comes out. So we'd just like for that proposition to carry over until we get clarity. I don't know if he's flying out of the state. I don't know what he's doing, but we want to reserve the right to recall him depending on where this goes.
I think we've already said that he has to remain subject to being recalled.
Yes, sir.
Advising salaries, the restrictions.
Yes. Your Honor,
If you need to sit down, want to stay seated, that's fine too, Mr. Hunter.
that's okay. That's probably better for me to stay down. I have two problems. The next witness is going to be Sally Smith. Number one, I have not spoken to her at all. We may need to have a discussion regarding what she should and should not say. In view of Your Honor's admonitions the other day, which I intend to abide by, but I want to make sure she understands. But on the other hand, I don't wish to have her cross-examined about talking to me when all I'm doing is instructing her about the court's parameters and the court's ruling.
Well, why don't Mr. Anderson and Mr. Hunter go talk to her jointly? That way, there's not going to be any misunderstanding.
That's fine, and we can, but that brings us to problem two.
Problem two.
In the interest of judicial economy, I can publish a couple of emails. So, I'm sorry.
What's problem two?
Problem two will facilitate what you, I don't know how else to put this, Judge. Siri took her to City Hall instead of here.
I'm sorry?
She went to the wrong place. Siri took her to City Hall instead of here.
She went to the North County Courthouse, or actually,
No, down the street, but she's about 10 or 15 minutes out. That's what I was.
because sometimes when people put in Google Maps, they take them to a Waffle House up off of Fort. You think it's funny? The problem is that happens all the time. To a Waffle House on North 41.
Is it any good?
Could be an advantage.
Well, City Hall's just 15 minutes from here. It's not too far.
That's what she said, Judge. But I mean, the traffic apparently was very bad this morning to start with, and this didn't help matters any. So anyway, we could, I think what I'm hearing from co-counsel here is that if you want to bring the jury in, we can publish a couple of things, and she ought to be here by then, and we can step out and talk to her.
Is there a deposition we can play?
We're clipping a couple now.
We're close to Hannah being done. I am not trying a third attempt at Malik until plaintiff's counsel has reviewed the clip report.
I've reviewed.
Did you cross?
I did, and I indicated one or two areas that you might want to look at.
Okay, but it needs to be clipped yet, Judge. I didn't want to have it clipped until plaintiff's counsel had reviewed it and agreed as to what was coming out. So it needs to be fixed, so it's not ready.
So no depositions ready to go.
How long would it take to clip it?
Well, I can't answer that question. But more than 5 minutes. I think there's a lot that has to come
Well,
out.
before I lose you, Ms. Quarles, O'Leary Johnson, I ruled on the plaintiff's objections. I don't think I saw defense objections to their designations. I don't know if I missed it or if none are coming or you just haven't had a chance to do it.
I will check on that, Judge, with the team. I also believe that we're ready to send you Dr. Rose. I believe the plaintiff has done their counters and objections. We just need to get you the dep and everything.
Well, if Dr. Sally Smith isn't going to be here for a few minutes, you can publish, but maybe after a few minutes of publishing, we'll have Dr. Malik's deposition ready to go, and then we can play that.
That'd be fine, Judge. I'm sorry about the delay.
Your Honor, I think the court could give us some guidance. As I understand it, that Chapter 39 efforts of Dr. Smith are going to be off limits for this. So it will be solely as to her actions at the hospital insofar as the issue over agency, and I guess that correlates in with any involvement on treatment teams or suggestions of treatment.
Here is the reality. The jury knows that Sally Smith has a role in the dependency court proceeding. And the jury knows that there was an ongoing dependency action. I am fine with, orienting questions as to her role in the dependency. What I don't want to get into is an examination of her 45-page report to come to the conclusion or her recommendation to the dependency court that Beata Kowalski had Munchausen syndrome by proxy. So a few questions to orient the jury about who she is and her background, that's fine.
No objection to that. Mine would be, to put a finer point on it, an instance would be the question over her conversations with Dr. Kirkpatrick, which could go either way. In one way, if she's an agent for the hospital and she had conversations with Dr. Kirkpatrick, and there's evidence in the record from Dr. Kirkpatrick and his memo at the time that he did.
I think I cut most, but not all of that conversation from the deposition designations last night. I think I left in one or two, but cut, I think, the majority of them, if I remember correctly.
Okay, this is for which depot?
Hannah. Oh, you said Kirkpatrick. I apologize. Because there were questions in Dr. Hannah's deposition about discussions with Dr. Sally Smith.
Yes.
I cut a good number of those out, but I left in a few, which those original questions and calls, it does not offend me, and I don't think it gets into Chapter 39, if there's just, hey, did you talk to some of these doctors?
Right. That is exactly what we wanted to ask, because it puts her on notice, obviously, to the extent that she is involved in the care of Maya Kowalski, that she knows she has these other doctors as a resource. There's Dr. Wassenauer, and then there's Dr. Hannah, and there's Dr. Kirkpatrick. And so I just simply want to ask her, did you have these discussions with them? Were you aware of this as of X time? And that's all I really need to do.
Judge, I had not intended to go that far. I'll make a proffer when it's all over with, but I read, I got a transcript of what Your Honor told me the day before yesterday, and I've in figuring out how I'm going to try to do this, I've tried very much to abide by it.
And I appreciate that. The fact that Dr. Smith has talked to a few or a bunch of doctors, that does not, I don't think that's problematic. It's once you start getting into the substance and the prosecution of the dependency court action, that cannot be discussed. So,
I will not.
did she have discussions? Yes, but once we get into the substance of those discussions, I think that's where we need to draw the line. Does that
I think so, Judge.
work with you?
We're going to inevitably touch on the fact that she was, as Your Honor pointed out, conducting an investigation, and she's doing this. But our entire point is that we're not talking about that. That's separate track, if you will. So I've tried to design this thing in such a way as to avoid that, and I don't know where the cross is going to go. That's not my thing. But what I've tried to do is focus on her role and lack thereof at the hospital, and her lack thereof with the treatment team, and the fact that what she did, she was doing as a CPT captain. That's the whole point of it.
Yeah, and I understand, and if you need to approach, I'm going to let you have approaching, and we can, if there's a specific question, we can deal with it. It's like in a car crash case, when a investigating officer is doing a car crash case and they switch it over to a DUI investigation, they change hats. and there's a very clear demarcation. We just don't have that in this particular case, and we'll just have to
Well,
address it.
I think from what I heard, Your Honor, I think I'm okay with if we just proceed. But I you know, there will be, on my end at least, there will be like passing reference to what she was doing, but I'm going to be talking about what her role was, not what she was doing.
Perfect. So let's do a couple of publishing of depositions. If Dr. Smith isn't here and Dr. Malik's deposition is ready, we'll do that. If Dr. Smith is here and Mr. Anderson and Mr. Hunter have spoken to her, then we can call Dr. Smith then.
Okay. I'm not sure we need to talk to her based on what Your Honor just, that's what you said.
I
do so, I don't care.
suspect it's better if the two of you jointly discuss with her what we just talked about.
Very well.
I can publish 3 emails at 4 or 5 minutes apiece. That'll take 15 minutes, and then hopefully Mr. Anderson and Mr. Hunt will be ready.
And if Dr. Sally Smith isn't ready, then hopefully by then the deposition is ready to go.
Yes, Your Honor.
Okay. Anything else before I bring in the jury?
Yeah, we need to talk to Sally Smith, and then we take it for the rest of it, Judge.
Bring in the jury. Dr. Smith is here.
Okay.
Jurors entering.
Good morning. Please be seated, everyone. I want to confirm that while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. And has anyone approached you about this case? No. And have you seen any media accounts about this case since you were last with us? No. Okay. Mr. Shapiro.
Thank you, Your Honor. We would like to now publish what's been received into evidence as Defendant's Exhibit 3144, email of Beata Kowalski to Beata Kowalski regarding coma day 1, November 18th, 2015.
That should be on your screen. I'm just waiting for all the jurors to be finished before we go to the next one. Does anyone need more time? Okay, more time. I think they need more time.
Okay.
Mr. Shapiro, I think you can go to the next one.
The defense publishes what's in evidence as Defense Exhibit 3145, email from Beata Kowalski to Beata Kowalski, Comity to 11/19/50.
Anyone else need any more time? Mr. Shapiro, you can go to the next one.
The defense publishes Defense Exhibit 3146, email Beata Kowalski to Beata Kowalski, 11/20/50.
time? Okay, well, more time, we need more time. Okay. Mr. Shapiro, I think the jury's ready at this point.
I think we're ready to call our next witness, Mr.
Mr. Hunter.
Very well, Your Honor. May it please the court, our next witness is Dr. Sally Smith.
The Mizio control.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Come this way. And you're gonna have a seat in the witness stand there.
Morning.
Good morning.
Tell us your name, please, ma'am.
Sally Marie Smith.
And what is your occupation?
I'm a pediatrician.
And where do you presently practice your profession?
I'm a partner in a pediatric general practice in St. Petersburg called Fifth Avenue Pediatrics.
And you have several other pediatricians that work with you in that practice?
Yes,
Okay. And that's basically a private practice of pediatrics?
it is.
Okay. Would you give the jury a brief, I think the jury's heard some of this, but if you give the jury a brief overview of your background and training in your profession, please.
Okay. My undergraduate degree was Bachelor of Science in Biology from Georgetown University in 1980. I went to St. Louis University School of Medicine and graduated in 1984. Pediatrics is a 3-year training, and so I did my first year and a half of my pediatric residency at what was then All Children's Hospital. And then I moved back to St. Louis and completed my residency at Cardinal Glennon Children's Hospital, which is the children's hospital affiliated with St. Louis University. And I did an additional year of training in what they call ambulatory pediatrics. I sort of had a career path trying to be a teaching general pediatrician, and so that was the focus of that additional year of training.
Okay. And did there come a point in your career at which you became interested in child abuse pediatrics?
Yes, actually, when I was in medical school.
Okay. Tell us how that came about and how you developed that specialty.
I believe I actually became interested first because of some children that were in the ICU when I was a resident who had bad injuries, and when I did my in medical school. I got ahead of myself. In medical school, I did a rotation with the county medical examiner who ran the morgue in the city of St. Louis. And because I was interested in pediatrics, she had me review all of the pediatric deaths from abuse that she'd seen over a period of maybe 10 years leading up to when I was there. And that got me very interested in the idea. And then, as a resident, I saw additional children that increased my interest. And then, in my fellowship in ambulatory pediatrics, I worked with the director of the sexual abuse evaluation program at Cardinal Glennon Children's Hospital. I worked with them like once a week or close to that, seeing children in their sexual abuse evaluation program.
Did you subsequently undergo additional training in child abuse pediatrics?
So, because of when I started this, which was in the late 80s, there wasn't really what's called fellowship training in child abuse pediatrics. So what I ended up learning over the years was mostly through experience. And beginning in 1988, I was the director of a sexual abuse evaluation program in New Brunswick, New Jersey at the Robert Wood Johnson University School of Medicine, and I was a teaching general pediatrician there. And then in 1990, I moved back to Florida, and I actually took a general pediatrics faculty position at All Children's Hospital. And as part of my job, I asked them if I could work with the child protection team. And so from there, I just ended up seeing virtually all the children that have come through All Children's Hospital for the last 32 years who needed evaluations for alleged child abuse and neglect. So I gained my training, if you will, in the trenches, just seeing children, looking things up, reading about it, checking with expert colleagues, learning from the radiologists, the neurosurgeons, the other people who work with these children down at All Children's, and ended up acquiring a pretty high level of expertise.
Did there come a point in time at which you applied for board certification in child abuse pediatrics?
Yes, so in 2009 was the first year that a board certification was made available for the specialty of child abuse pediatrics. And at that time, as I mentioned, because there wasn't really a fellowship in child abuse pediatrics, which would be 2 or 3 years additional training, the people who were allowed to sit for the exam could also be people who had at least 5 years experience in evaluating children for child abuse, were working in that specialty for at least 20 hours a week, which I qualified for both of those. And also you needed to have essentially a letter sent to the American Board of Pediatrics from someone who was kind of a recognized expert in child abuse, who would sort of vouch for you, that you were a person that should be allowed to take the exam. So I took that exam, I believe in November of 2009. It was in the fall. And then I think early January was notified that I had passed the exam and therefore was board certified in child abuse pediatrics.
Okay. Now, did there come a time in your career at which you became involved with the child protection team for Pinellas County?
Yes, so I worked for All Children's. I'm going to keep leaving out the Johns Hopkins because I've just been using that term for 32 years. But anyway, when I went to All Children's to join the faculty, I started working with the child protection team in Pinellas County, and the hospital basically had an arrangement where they billed the child protection team when I saw cases for them for the hours that I worked, and allowed me to have the time to do that. And so for that 12-year period when I was working for the hospital, I was on campus. And so vast majority of the children who were hospitalized where there were allegations of child abuse and neglect and a medical evaluation was requested, I did those evaluations. So I was a consulting pediatrician for the child protection team during those 12 years. In November of 2002, their medical director left, and they asked me if I would take over as the medical director. So at first I tried to work out a way to keep my job at All Children's and also do that, but it wasn't really very practical, and so I ended up resigning from All Children's at that time and became the medical director for the child protection team. So for Pinellas County, that's about a 20-hour a week. I ended up working more like 26, I believe, over time, but it's about a 20-hour per week job. And so I did that, and within a few months, I started working at this private practice where I still am.
Okay. Let me back up a little bit there and try to clarify a couple of things. You indicated you resigned from what was then just All Children's Hospital,
Right.
no Johns Hopkins,
Right.
in 2002. Is that right?
Correct.
And at that time, you became the director of the child protection team for Pinellas County, correct?
Right. The term they use for the physician is the medical director. So I was the medical director. Yes.
So, what is a child protection team, and who constitutes it? Who were you working for at that time?
So the child protection teams, Florida has a kind of a model program for the country, and it was set up in the late 70s. I think that All Children's started.
Objection, Your Honor. This is beyond scope.
Sustained.
Move to strike.
Sorry?
Sustained.
Can we approach you?
Sure. Mr. Hunter's going to ask a different question, and the jury will just disregard that last question.
I'm going to fast forward a little bit, if we can, without a history lesson. if
Okay.
you will.
Sure.
The CPT. Well, let me back up. We've talked about that you resigned from Johns Hopkins from All Children's Hospital in 2002.
Right.
And have you ever worked for them or been employed by All Children since then?
No.
Have you ever been employed by Johns Hopkins All Children's Hospital
No.
or Johns Hopkins?
No.
Okay. Without going into the historical details, well, let me lay the predicate this way. When you saw Maya Kowalski in 2016, were you the medical director of the Pinellas County Child Protection Team at that time?
Yes, I was.
Okay. And you had been so since 2002 in one role or another.
Correct.
And tell the jury, if you would, what a child protection team is.
Okay.
Objection again beyond scope.
No, she can answer that question.
So in Florida, each county is covered by a child protection team. It's a multidisciplinary team that includes a medical director, usually nurse practitioners or sometimes other physicians from the county who are supervised by that medical director, and social workers who serve as what are called case coordinators. So they communicate with all the people involved in a particular investigation or case. And they also have like a team psychologist, for example, that's contracted, a team attorney, I believe. So it's a multidisciplinary team with these members, and it provides, especially in Pinellas County, one of the biggest functions of the child protection team is to provide medical evaluations when there are allegations of child abuse and neglect. And there are certain criteria that are set up under statute in terms of which kinds of situations warrant a medical evaluation. And so we kind of follow that list, if you will, in responding to requests for evaluations. The vast majority of the time, the request is made by the Child Protective Investigation Division under the Department of Children and Families. The child protection teams are under the Department of Health in Florida, and so they work side by side, but DCF doesn't run the child protection teams. And so they request for us to help them in investigating their case by looking at the medical information and guiding them in terms of whether there's medical evidence that would support a diagnosis of child abuse and neglect, and whether a child's safety is at risk as a result of that.
Okay. So in any given situation of a child abuse investigation, what is the role of the child protection team and its medical director in pursuing that investigation or facilitating that investigation?
So primarily the role is to provide that medical evaluation, and it kind of varies exactly how much work is required to do that. But also we end up being a go-between with the dependency attorneys, the child protective investigators, the detectives or law enforcement that may be involved in a case, again, to provide that medical expertise to assist everybody in making a good decision for the child. We present information in court on a fairly regular basis and assist the dependency judge or the juries in evaluating the cases for whatever legal action may be needed. And one of my roles, which is also in statute, is to provide education for community medical providers.
It's going well beyond. Overruled.
So in that role, particularly for a teaching hospital like Johns Hopkins All Children's Hospital, it's the residents are required to have a certain amount of training in evaluating child abuse and neglect. And so over the years, I've been involved in that element as well to help provide education for the medical students and residents there at the hospital.
Okay. And do your statutory duties as medical director of the CPT, in your understanding, require that you consult with healthcare providers in a situation where a child has been sheltered?
There certainly are scenarios in which that's an important component of what were my responsibilities. Not always, but many times, especially in more complicated cases, the treating physicians at the hospital may need an ability to consult someone who is more expert in child abuse or neglect case for a variety of reasons.
Now, in the fall of 2016, and particularly in September and October of 2016, you told us that you were the medical director of the Pinellas County Child Protection Team at that time.
Correct.
What other hats did you wear as a pediatrician in the community at that time?
So I had my private practice. At that time I was working half-time there. Now I'm full-time. And I also, ever since I moved to Pinellas County in 1990, I had active medical staff privileges at All Children's Hospital. I do to this day. And that doesn't mean anything about being employed by the hospital or being somehow under the hospital, but the medical providers that go in the door there have to have credentialing in order to go in and see patients, communicate with the other physicians, review the medical records and the radiology studies and lab work and all those kinds of things. And so that was essentially another hat where I was active medical staff with the hospital. And then as a community pediatrician, and obviously I'd been there for 12 years, so I was well known to the medical staff members, and they asked me to be a representative on a number of hospital committees over the years as a representative of the community to sort of bring that to the table. So I think at the time in 2016, those were the main additional roles that I had besides being the medical director of the child protection team with regards to all children's.
Okay. At that time, in the fall of 2016, did you have what we refer to as staff privileges, medical staff privileges at hospitals other than Johns Hopkins All Children's?
Yes, I believe the only one as of 2016 would have been Bayfront Medical Center, which is Orlando St. Pete now or something, where I've had privileges since 2002 to see newborns in the nursery there. I mean, I have staff privileges, but that's what I actually use them for.
Okay, so you would have privileges to practice both at Bayfront Medical Center and at Johns Hopkins All Children's Hospital.
Yes, and in addition to being able to walk in the door and evaluate children as the medical director of the child protection team, in 2016, I still had some patients from my practice that were complicated patients that sometimes I would admit to the hospital and manage their care. That was a different hat. That's my private practice side. That's all been taken over by the hospitalists in recent years, but I used to do that multiple times a year, admit my own patients to the hospital.
Okay. Now, in this particular case, how did it come about that you became involved with Maya Kowalski?
So the main way I became involved was because there was a report concerning child abuse or neglect.
What's the scope of that? Factor groups report that, unless I get
This is,
You may continue, Mr. Hunter.
thank you, Your Honor. May it please the court. Let me focus this a little bit.
Okay.
In early October of 2016, did you receive a call regarding Maya Kowalski from Dr. Beatrice Tepa-Sanchez?
Yes, I did.
And at that time, when you received that call, did you have any knowledge of Maya Kowalski or her admission to All Children's Hospital?
No, that was the first I learned of it.
Okay. And Dr. Tepa-Sanchez contacted you regarding concerns that she had?
Yes.
And what did you do to tell us very specifically, and not at any length if you would, what you did in response to that phone call?
I talked to her on the phone about, she was asking me about what to do about a possible case of, I believe her terms were Munchausen syndrome by proxy. And we talked about the kinds of things that are needed to assess that diagnosis, such as medical records.
Objection as to
What?
You can continue, Mr.
Okay, great. Sorry.
And we also talked briefly, as I recall, about this specific case. And I tried to give general advice in terms of how pediatricians can approach concerns for Munchausen syndrome by proxy, or what I prefer to call medical child abuse.
And were you called at that point as a member of the child protection team or as a medical staff member at Johns Hopkins All Children's Hospital, or do you know?
My understanding was I was being called as the person they all had known for 32 years to be the hospital expert in child abuse and neglect, as an active medical staff member, and another active medical staff member was seeking my assistance, advice about what to do about a case where there was concern.
Now, with a call such as that, would that be considered a consultation?
That would be my understanding of what that's what I thought it was.
Did you access the medical records from Maya Kowalski at that time?
I believe I did briefly, yes.
And did you take any further action as far as evaluating the patient herself and her medical care at that time?
No, because to do anything as a child protection team medical director, I need to be asked by the investigators to provide a medical evaluation. And at that time, to my understanding, there was no actual investigation ongoing yet. And Dr. Tepa Sanchez wasn't the person under Florida law who can ask me to provide that medical evaluation. So it was a Saturday, as I recall, 1-ish in the afternoon, and we had a little discussion at that time, and then I honestly didn't think about it more, do anything more about it until Monday when I got that referral where the child protection team was asked to provide a medical evaluation.
So between the time that you spoke with Dr. Tepa Sanchez and looked at the chart briefly and the time you were advised of an investigation on Monday morning,
As I recall, it was Monday morning, yes.
did you take any action to render diagnosis, care, or treatment to Maya Kowalski?
None whatsoever.
And so you had a brief telephone conversation, and until you were told there was an investigation, you took no other action to involve yourself in this patient's care.
Correct.
Now, once you were advised of the investigation, did you undertake well, first of all, and I want you to answer this question very narrowly.
Okay.
Were you advised of an investigation and asked to conduct a medical evaluation as the medical director of the child protection team?
Yes.
And is that the point at which you began your investigation of the case?
That's the point at which I began my medical evaluation of the case. I wasn't the investigator. Those are other people. I was providing a medical evaluation for the child protection team to assist those other people.
Okay. And in conducting that investigation, were you acting as a medical staff member of All Children's Hospital, in other words, a pediatrician in consultation, or were you acting as the medical director of the child protection team?
You know, there's a slight overlap because the privileges that I have at the hospital allow me to review their records and enter the building and examine children and things like that. So there was a slight element of my active medical staff credentialing that was in play, but primarily I was acting as the medical director of the child protection team.
Who was conducting the care of Maya Kowalski at that point?
At that point, she was in the pediatric intensive care unit at All Children's, and so the ICU physicians, the pain management team, I'm not sure if there were any other consultants that were involved at that point. Certainly all the nursing staff and the support staff and everything were the ones that were managing her care. In not just this case, but in child abuse cases, I don't really get involved with the management, day-to-day management of the children at all. My role is specifically to do this medical evaluation. And so I focus on that part and not really anything related to, whether the child gets a regular diet or what medications they're on or how often they're getting vital signs or any of that kind of thing.
And is your involvement in the medical evaluation as the CPT medical director part of in your understanding, part of your statutory duties as the medical director of the Child Protection Team?
Yes.
With respect to Maya Kowalski, did you ever write a consultation in her chart?
So the physicians that are treating the children that I see down there for a child abuse evaluation obviously are going to be helped if they know all of the medical data related to that potential diagnosis. And so recently there's a different electronic medical record system and it doesn't exist anymore, but at the time that I was involved with this case, what I would routinely do would be to provide my medical report to the treating physicians at the hospital to assist them. And that's okay when they basically ask me if they can have my report, then I can provide it to them. There was a sort of a super confidential kind of process that was set up so that not, the housekeeping staff couldn't look at these medical records, but a physician who was logged in that manner could see the Child Protection Team report and could utilize that for either that time they were in the hospital or maybe a subsequent time they were in the hospital. That doesn't really occur the last 4 or 5 years or so, but that was in place at that time.
But your report would not have been placed into this portion of the chart you're referring to until you actually rendered it, completed it, and signed it much later, correct?
Typically correct, yes.
Okay. When you are in private practice, when you're managing a patient, let me ask you this way. When you're managing a patient in a hospital, whether it's Bayfront or Johns Hopkins or wherever, and you call for a consultant, a specialty consultant,
Yes.
what typically happens? You get a consult report in the chart?
Right. I mean, I had many years of experience, like as an actual in-hospital person, and that's what's typical. A consult order gets written. In this case, it's different because there's no consult in the All Children's medical record for a Child Protection Team evaluation. That has to go through the Child Protection Team and Child Protective Investigations in the state of Florida. So there's never a consult order for a child abuse evaluation from a hospital physician. What they do is they make a report, or their typically social worker that's involved with the case makes a report to the hotline. That's how it works in Florida. That's how it works at All Children's.
Okay, so during the time that Maya Kowalski was at All Children's, did you ever write an order in her chart?
No, I did not.
Did you ever write a progress note in her chart?
No.
Did you from time to time talk with the physicians that were caring for her?
Yes.
But did you see her or round on her on a day-to-day basis?
No. I saw her one time, I believe on October 13th, 2016, and I saw her one time in early November. Probably between 5 and 15 minutes each time. Those were the only times I ever saw her while she was in the hospital.
Okay. And what was the purpose of your seeing her those 2 times?
So part of my medical evaluation is supposed to be a physical examination. So when I saw her on October 13th, I was trying to perform a physical examination, which basically she declined. So in November, again, as part of my job as the Child Protection Team Medical Director, I'm supposed to do a physical examination, and I'm also supposed to provide photo documentation for investigators and whoever else is involved in the case. So I went that day in early November to try to take some photographs of her lower extremities in terms of trying to essentially document the absence of a problem.
And did you take any such photographs?
I did not.
Did you ever interview Mr. or Mrs. Kowalski?
I took, as part of my medical evaluation, I took a fairly extensive history from Mrs. Kowalski and a much more abbreviated history from Mr. Kowalski. The meeting with Mrs. Kowalski took place on October 11th, 2016, and the relatively brief interview or history taking with Mr. Kowalski occurred on October 13th.
Okay. Did you ever speak to the two of them together?
I did not.
When you spoke with Mrs. Kowalski, first of all, where was it?
So at that time, Maya was still in the pediatric ICU. They have a family conference room kind of thing outside of the main entrance to the pediatric ICU. And because of the investigation that was being initiated and everything, I scheduled a time where the child protective investigators and the people in law enforcement that were investigating the case could join me to while I took my medical history. So there, as I recall, there were about 5 of those people, 2 or 3 child protective investigators, I think 2 law enforcement people, and Mrs. Kowalski. They were all in that room already when I got there for the scheduled meeting, which I believe began at 5:45 in the evening on the 11th.
Okay. Did you identify yourself to Mrs. Kowalski?
Absolutely.
How did you identify yourself?
I always say, I'm Dr. Sally Smith. I'm a pediatrician with the Child Protection Team. And that's what I said to her.
And the other folks who were there were either law enforcement or child protection investigators?
Yes. It's possible one of the nurses was in there, but otherwise those were the people that I recall being present.
Okay. Were you wearing a lab coat?
No.
Do you ever wear a lab coat at all?
Well, at All Children's, no. I do in my office now since the pandemic, but for 20 years I never wore a lab coat.
Do you wear, when you're in a hospital, do you wear a particular identification badge?
Yes, I have to wear my Johns Hopkins All Children's identification badge to come in the door and to, move around. There's all these little things you put your badge up to open doors. And I have a similar one for Bayfront.
Okay. So if you're in Bayfront, for example, you wear a Bayfront badge. If you're at All Children's, you wear an All Children's badge.
Correct. And when I go in between, I switch badges.
Okay. When you spoke with Mrs. Kowalski, was there any question that you had identified yourself as a member of the Child Protection Team?
Absolutely none.
And did you conduct that investigation in any way as an employee or agent of All Children's Hospital, of Johns Hopkins All Children's Hospital?
No.
Did you ever hold yourself out to Mrs. Kowalski as acting on behalf of Johns Hopkins All Children's Hospital?
No. As I said, this was a scheduled meeting. Everybody knew exactly what was happening.
Did Mrs. Kowalski know?
Absolutely.
How do you know that she knew that?
Objection, speculation.
Sustained.
Are you aware of how Mrs. Kowalski might have known that this meeting was going to take place?
As I said, they were all in the room when I got there. So she, and I believe some of these people had already interviewed her as part of their investigation. She probably recognized some of these people. They got on their badges and their, work-related clothing and things like that. So,
Objection, again,
overruled. She can say what she saw.
Granger.
So, and I introduced myself. I don't quite see how it's possible that she didn't know who I was and what was happening.
How long did that meeting take place?
About an hour and a half.
And you subsequently had an opportunity to speak with Mr. Kowalski?
Yes. So,
I'll
Okay.
follow up on that. When did you talk with Mr. Kowalski?
so that was on October 13th, and I'm honestly not sure exactly what time.
Okay. And how long did that discussion or meeting last?
I would guess about 10, maybe 15 minutes.
And who was present for that meeting?
The bedside nurse, I'm pretty sure she was still in the ICU that day, and Mr. Kowalski and Maya.
Did you identify yourself to Mr. Kowalski?
Yes, I did.
And how did you identify yourself?
I said, I'm Dr. Sally Smith. I'm a pediatrician with the Child Protection Team.
And did you at any point advise Mr. Kowalski that you were acting on behalf of Johns Hopkins All Children's Hospital?
No.
Were you attired in much the same way as you were when you spoke with Mrs. Kowalski?
I was wearing professional street clothes both times.
Okay. And again, no lab coat.
No. I would have had my badge on both times because I was in the building, but otherwise, just professional street clothes.
Now, at the time that you spoke with both Mr. and Mrs. Kowalski, and I think I'm getting the dates right, around the 11th and the 13th of October, respectively, were you aware of any efforts being made to transfer Maya to another institution?
So I would say during that week, I knew that that was being investigated by, I believe, the hospital. I can't tell you exactly what day I knew that, but I definitely knew that there was an effort being made to transfer her to an inpatient intensive rehab facility.
And were you involved in that effort at all?
No.
Were you directing that effort at all?
No.
Were you directing any of the medical care of the patient at that time?
No.
How did you know that was going on?
That's why I'm not sure exactly the time frame. I know that week there was a multidisciplinary staffing that took place with people from the Sarasota County investigators and Child Protection Team and myself. And I believe there was discussion at that meeting. I believe that meeting was on the 13th, but I'm not 100% sure. But there were multiple discussions that I had with the treating physicians at All Children's that they were trying to make that kind of thing happen.
And did you have any understanding about whether there was an effort being made to wean Maya Kowalski's medication or reduce her medication as part of that effort?
I did not really, have any involvement with any of that. I believe at one point later in October, maybe right around now, October of 2016, that I knew that was happening.
Okay. And did you, once again, learn of that from the physicians directing her care, or did you attempt to direct that care yourself?
I learned that from communication with the attending physician.
Okay. And do you typically follow that as part of your statutory duties as Child Protection Team medical director? In other words, follow the course of the patient's care.
Yes. Typically when I've seen a child, and then as I'm writing my report, I kind of go back in the chart, see what's happening, put some of the quote-unquote hospital course into my report, and then, reach the conclusion. This was a much more extensive, lengthy process. So at that point, at the end of October, I hadn't, done any report or anything, but I was still in communication with them related to what was happening with the child abuse part of the case.
Okay. Now, let me ask that we put up Trial Exhibit 2123-723 in evidence. And let me ask you to take a look at this, Doctor. It's an email from Kathy Beatty. Do you know who Ms. Beatty is?
Yes, I do.
And did you, in fact, make a request of Ms. Beatty to get together with the treatment team to talk about Maya's upcoming needs in December?
Sorry, I got my stuff in front of the screen. Yes, so I believe at that time I was in communication with the dependency attorneys, and there was a need to...
You can answer that question.
There was a need to present to the judge what options he could consider and choose from in terms of what the child's needs were, what the options might be for those kinds of treatments and things, and
Let's wait for the next question, Dr. Simonson.
Yes, let's
Maybe approach on that.
Sustained. Members of the jury, you're going to disregard the answer that Dr. Smith was just giving. Mr. Hunter will ask a different question.
let me ask a kind of a bottom line question here first.
Hold on a second. Can I see the attorneys again? You may continue, Mr. Hunter.
Okay, please go ahead. Thank you, Your Honor. Going back to this exhibit, had you asked to meet with the treatment team at this point?
No. I was making that request in my role as the medical director for the child protection team to assist with that side of the situation.
Okay. Were you a member of the treatment team?
No, and I didn't attend this meeting.
Oh, so you wound up not attending this meeting?
it wasn't for me to be there, it was for them to have the discussion.
Ah. And you wanted to know what their consensus was. Well, I mean, strike that, never mind. Did there come a point at which you became aware of any pictures or videos being taken of mine?
Yes.
And tell us in general how that came about.
I'm not sure from the standpoint of the treating team at the hospital. From my standpoint, that was related to attempting to have some photo documentation as part of my evaluation and that could be available as part of the investigation.
Was it your understanding, well, did you have any understanding of whether the treatment team desired any such pictures for clinical reasons?
I believe so, but what I can speak to is what I was doing or my role with it, and my role was related to this attempt for some, in this case, video documentation for the purposes of the investigation.
So was there ever any point during this patient's entire hospitalization at which you were part of the treatment of the team rendering clinical care to Maya Kowalski?
No.
And did you ever hold yourself out as such
No.
to the parents?
No.
That's all I have for now, Your Honor.
Mr. Anderson.
Dr. Smith, how many times have you testified in court?
Probably over 300.
And how often have you met with defense counsel?
Well, pretty often, because usually there's a deposition in cases where I'm testifying. Oh, this one? 0.
You did not meet with Mr. Hunter
I did not.
yesterday? Did you have phone conversations with him?
I did not.
And not an email?
No.
In the week before, did you?
No.
How did you know to come here today?
Because my attorney from Suncoast Center's insurance company told me to.
Are you still doing what you were doing in 2016 to this day?
I'm a pediatrician. I resigned from the child protection team last July.
You wear several hats, Fifth Avenue Pediatrics, private pediatric practice, right?
Yes.
And then back in 2016, you were more or less director of the Johns Hopkins Child Abuse team, right?
They don't have a team. They had residents that came to our clinic to learn about child abuse pediatrics once or twice during their second year of training. And I was the designated director for that rotation for them. And if we had maybe 5 or so over the 20 years I was the medical director, residents who came and worked with us for a month, so I would be the person that would be supervising them for those rotations.
All right, so you're in charge of the residency, and
For
so
those things.
and so you were considered at this point by Dr. Tepa Sanchez as the go-to person for Johns Hopkins, insofar as the.
Sustained.
Have you ever heard that you were referred to as a go-to by the doctors there?
Well, they wouldn't be saying that to me, so I'd have to say no. I don't know what they say amongst themselves.
Okay. Now you said though that you weren't a part of the treatment team. Did I understand your testimony?
I was not.
Here?
Correct.
Can we bring up Exhibit 1002-0005? Next to last paragraph, bottom sentence.
I'm sorry. Oh, okay. I see at the very top.
The last,
Barely see the discharge summary note. Okay.
All right.
Okay.
Now, you weren't and didn't have any training in psychiatry, right?
Just rotations in medical school and residency.
You were not a pediatric psychiatrist.
Certainly not.
You were not a pain specialist.
No.
You were not an anesthesiologist.
No.
You were not involved in rehabilitation medicine.
No.
But you were included nonetheless in this treatment team, were you not?
No.
Let's go to 002-0006. And let's look at the bottom paragraph, third line. I think it's the last of the second and top and the third sentence. Nope. No. Above. No. This is at 0006, and I'm looking for the. All right. So, Dr. Sally Smith was heavily involved in her care. Is that true?
As the medical director for the child protection team in a complex medical child abuse case, yes, that's correct.
Well, you were involved in considerably more than that, were you not?
Not in any type of day-to-day treatment of the child, but certainly in a role coordinating some of the elements related to the investigation in the court case.
Well, getting Maya Kowalski off of all of her medications is not part of your job with CPT, is it?
Well, so
Is
that
it,
was...
or isn't it? Yes or no?
Excuse me, Your Honor, did the witness answer the question?
As soon as she says yes or no to whether it was or was not part of her
Why
job.
don't you answer the specific question? If you need to explain, you can start explaining.
I'm sorry, could you just state the question again one time?
Sure. Well, deciding what medications Maya Kowalski should be on or whether to take her off of medications is not part of your job description at child protection, is it? Or was it?
The
Is that
part
yes
about...
or no?
Yes, but I have to explain.
Yes, it's part of your job to do that, to manage Maya Kowalski's medications.
May I explain?
Well, yes.
So the part that was part of the question was related to taking her off medications. In cases of medical child abuse, one of the things that is important to try to do in a controlled setting like a hospital is if a child is on medications that may not be necessary, that the treatment team would consider to wean those medications in that controlled setting.
All right, so were you part of the treatment team or not?
I guess it's sort of threading the needle. I wasn't writing any orders. I didn't tell them which medications to stop or wean or anything like that. But as part of the whole evaluation of medical child abuse, there's a component of what happens when they aren't getting all these medications? And so that specific little part of it was within my role.
Exhibit 2116, please. Now, you just told them to get her off as many medications as possible. Down, number 15, next to last from the bottom. I think there's a misspelling there, but we can agree.
And I believe the legal
Is
term
that
is
a text from you? To
Yes,
Paula
it is.
Dees?
Yes, it is.
The Paula Dees that testified, well, you wouldn't know. Probably already, but is that as many meds, it just says meds here, but it's supposed to be meds as possible?
Yes, and her reply is the last one's going off today.
Okay. So were you or were you not advising the treatment team, as part of the treatment team, to take Maya Kowalski off of all of these medications?
I was assisting them from the standpoint of the medical child protection team, medical child abuse realm. And as the reply makes it clear, they were already doing it, and I didn't even know they were. So certainly wasn't directing that process.
You didn't know what they were. Weren't you involved in Maya Kowalski's lab results as well?
I'm not sure what you're talking about.
Exhibit 1001-0317. On November 15th, 2016, with Dr. Pagan, as part of the child protection, the treatment team, did he consult with you about an extensive chart review and recommendations?
So again,
I'm just asking whether he did or didn't.
well, clearly, I believe I had some discussion with Dr. Carroll, who this is, she's one of the hospitalists, and so that's her note. So clearly, we had some discussion about documenting that certain lab tests presumably were now normal that had been abnormal, but I didn't order the tests or anything like that.
Are you saying that where it says in a progress note in the Johns Hopkins records, which you say you have access to, right?
Yes.
It says that the treatment team leader spoke at length with Dr. Sally Smith, you, right?
Yes.
That you had done an extensive chart review, right?
Yes.
And you were making recommendations regarding lab tests, right?
I was, from the standpoint.
And you were making observations of whether they were abnormal. Is that right?
I knew she had abnormal tests that I had seen in all of these medical records that I reviewed, but I don't. I mean, I'd have to look up and see. I don't really recall if these lab tests done in mid-November had any abnormalities.
A CBC, a CMP, a UA, a lipid panel ordered. Lipid panel is to check her cholesterol level, is it not?
Right. At one time, hers was 363, I believe, quite elevated at various points.
So now you're in charge of her cholesterol as well? Is that right?
The lab tests had certain abnormalities that, based on my record review, I suspected were related to medications and potential toxicity. And so in evaluating the medical child abuse, one of the things we're trying to assess is if harm has been done, and hopefully it's reversible. So that was the thought process, the mindset that I was approaching this discussion with Dr. Carroll.
You're not a pharmacologist, are you?
I'm not.
Also, an IG profile. What's an IG profile?
Immunoglobulin.
And an IgE?
So that's a specific one of the immunoglobulins. There are A, G, M, and E.
and a RAST test to check and see if she had allergies?
Correct. That was one of the things in the medical records that was said to cause some of her symptoms.
Are you an endocrinologist or an allergy expert?
I see a lot of children with endocrinological and allergy problems in my general practice, and I saw a lot of them in my role at All Children's for 12 years, but I have neither board certified specialty.
You don't have a specialty in either one of those, do you?
I just said that, right?
And you were worried about her dog dander allergy, right?
Yes.
And dog dander allergy is clearly part of Munchausen by proxy, right?
It is.
Yes.
Let me continue.
No, I was just sustaining that objection.
All right. And on December 13th, 2016, and I realize you might not recognize a lot of the dates, but to put it in context, by December 13th, 2016, now Maya had been at the hospital for what, 1, 2, almost 3 months? 2 months.
October
2 months.
17th to December 13th would be a little over 2 months, right?
Right. And you were still on the team, were you not?
I was still the medical director of the child protection team.
Well, you were part of the treatment team, were you not?
I was not.
1001-0200. Did you or did you not confer with the team regarding creating a behavior chart? Bottom last 2 sentences. Highlight, please.
So,
Did you or did you not become involved in creating a behavior chart for Maya Kowalski?
looking at this note, I think I misspoke earlier. The way that I didn't see any of these ahead of time. But the way the email was written, it was that they should meet, but it looks like I probably did actually attend that team meeting. And so it looks like these were the things that were discussed related to coming up with this list of things that would potentially help the court that was involved at the time.
You just said you hadn't seen these prior to this. Why would it be important for you to see all of these notes in the medical record prior to this, if all you're here to do is tell the truth about what you know?
Objection, Your Honor. Argumentative.
Sustained.
And then you had the pain team on documenting pain weekly. Is that right?
Well, I mean, it speaks for itself. These were the things that they said we talked about. I don't have an independent recollection of this specific meeting. And certainly, I've been reviewing a lot of stuff the last couple of weeks, but I did not see this nor Kathy Beatty's email ahead of time. So, I'm just going by what I'm seeing right here at the moment.
Okay, so then you were involved in changing the room?
Yeah, I'm not really sure what that's in reference to.
Was that changing the room to the 48-hour room, the surveillance room?
No, that was back in November. So
Were
I'm
you-
not.
I'm sorry. Go ahead.
I was going to say I'm not sure what this is talking about.
Okay. So were you aware that during that 48 hours, Maya Kowalski was forced to urinate and defecate on herself because she could not get over to the commode?
Objection, argumentative, and facts not evidence.
Overruled. She can answer.
No.
Were you part of the decision to put the commode just out of reach of her so that she could not get to it herself and had to rely on a nurse?
Absolutely not.
Were you part of any decisions to make sure that the nurses moved slowly so that she would be forced to have the decision of either urinating on herself or worse, or, I guess, calling and waiting?
No, I have no idea about that or what you're talking about.
Would that be child abuse?
I think that would be a stretch.
Objection, argumentative.
Sustained.
All right. So, if we go back then, as you were talking about, that was in December. If we go back then into October, were you again part of the treatment team with Dr. Hart, Dr. Elliott, and Dr. Dees?
No.
1001-0429, please. Right above the line there, please, and that right there. Now, please take a look at it, read it if you can.
Yes, I have.
All right. And here, Dr. Dees states that she spoke to you along with Dr. Hart and Dr. Elliott. Do you see that?
Yes, I'm pretty sure this is in reference to a meeting that we had on this, I think it was that day, on October 18th. One of the things that's recommended in evaluating medical child abuse is to meet with the treating physicians and discuss what their observations are and everything so that I can then convey that in my report that I wasn't just sort of like out there rogue making this diagnosis, that there were other physicians with some of these other areas of expertise that I had discussed the case with and had the opportunity to hear their expert opinions. So Dr. Hart was the rehab physician, Dr. Elliott was the anesthesiologist, and Dr. Dees looks like would have been the hospitalist that was the general pediatrician taking care of her at that time. So that was the purpose of that meeting.
Well, it says here that the purpose, the first one, was continue with the current plan, right?
I don't think that's what it says. I think those are two separate things.
Right. Well, wouldn't a treatment team be the team deciding about keeping with the current plan?
Yes, and I think that's what Dr. Dees was referencing. So this is her brief note at the end of the pediatric residence note, and they will put in a few sentences, sometimes more, and so I think there are three separate sentences here where two separate sentences that she added to, convey what her plan was for that day as the attending physician.
All right, I was just simply asking you whether you were part here of a note in which the current plan described there was discussed.
I understand, I think, what you were asking, and I'm answering the question to the best of my ability.
Okay. You're aware that on October 8th of 2016, there was no active state investigation of the Kowalskis?
I'm not sure exactly when the report was made, but I think at least part of the day on the 8th, that is correct. It was either late that day or the following morning. I found out about the case the following morning, so the 9th. Yes.
So what were you doing accessing Maya Kowalski's private, confidential medical records on the 8th if you were just part of the child protection team and there was no investigation?
I was doing so under HIPAA's what's called TPO exception to the confidentiality guidelines, which allows for...
Objection. Move to strike for legal conclusion as to what the statute says.
I'm going to sustain the objection. Mr. Anderson, you can re-ask the question, and we'll get to a break in just a couple minutes. Mr. Anderson, within 5 minutes, we need to take a break.
So true or false, you accessed Maya Kowalski's medical records on the 8th.
I did.
Prior to that, you did not contact Jack or Beata Kowalski. True or false?
Correct.
Is it not true that you often walk in after...
Mr. Anderson, if you're going to a different,
I am.
then why don't we take the break now? Members of the jury, do not discuss this case amongst yourselves. Do not do the investigation and receive more information. Let's try to keep it to a 10-minute break.
All rise. Jurors exiting.
Jury's out of our presence. Sorry about that, Mr. Anderson. The court deputy was telling me one of the jurors needed a break. So,
Yeah, I saw it. Good catch.
Dr. Smith, you're in the middle of your testimony, so you're not allowed to talk to, well,
Sure, I'm aware.
either side.
I'm aware.
Okay, 10 minutes. Let's keep this no more than 10 minutes.
Yes, sir.
All rise. Court in recess.
to get advice.
Great. And then how about O'Leary Johnson?
Oh, I'm sorry, I meant O'Leary Johnson. I said those, I meant O'Leary Johnson.
Great. So there's nothing more with O'Leary Johnson that I have to do.
That's correct.
Great. Thank you. Do we know where Mr. Hunter is? Or?
You want me to find them, Judge?
Let's just give another minute or two.
I can tell you there's a line of age.
I wanted to ask the court if, while the jury's out, could we?
Well, Mr. Hunter's not here.
Yes, sir.
Is this a conversation that we need Mr. Hunter for?
I only wanted to mark what the doctor brought in.
Or why don't we wait for Mr. Hunter at that point?
Yes, sir.
And speaking of Mr. Hunter. Let me ask the lawyers this. There's been several references to Dr. Carroll and Leslie Carroll. Do we need to say anything to the jury that Dr. Leslie Carroll and I have no relationship, or just leave it alone?
I think they're clueless about that.
It's up to you, Judge. I mean, I don't.
I'm sorry? And as a reminder, my brother is a Dr. Carroll.
Yes.
And so,
It might be a good idea
I
to
think it is.
say something just for that reason.
Yeah.
Because they may have heard Dr. Carroll. Okay.
I don't think it hurts.
so I'll just make that mention. Now, Mr. Anderson, there was another issue you wished to address with when Mr. Hunter was here.
Oh, yes. Thank you, Judge. All I wanted to do was mark for identification what Dr. Smith brought in with her to testify with.
You mean all those notebooks?
Well, that's a good point. Man, I couldn't see what you're talking about here.
Let's just talk practical from the clerk's perspective. If Dr. Sally Smith has only looked at like 2 pages this whole time,
Yes, I see the court's.
I have no, I mean, you mark that.
Yeah, I just think that the binder she has open right now is the only thing I would want. That's the only thing I've seen come out of it is this one binder that is before her right now.
well, I don't think she's looked through the binder. I think she's only looked at the couple pages in her hand, so.
I don't have any issue with her looking at her, with marking what she has looked at. But that should be it.
I always thought when they brought stuff to the stand, you could explore whatever they brought.
Well, if she's not looking at it, and it's just more or less a prop, if you will, at this point, I just don't want to have 5 or 6 5-inch notebooks having to be given to the clerk who already has so many notebooks.
She's got quite enough notebooks. Yes, that's what I was just suggesting. Only this one that she has got open right now and referred to. I have not been able to see how many pages, what she's referred to, but I do know that it appears to only be one notebook.
Dr. Smith, why don't you close the
Sure.
black notebook and only keep out what you've actually looked at, which is what's in your left hand. Yes.
Okay.
Okay.
Good.
So, as a reminder, if Dr. Smith is going to look at any of those items, then we'll probably mark that. But just to mark 5 binders, to mark them, let's not do that.
Understood.
I don't know if it's proper, but all of these are shared documents that are bait stamped, except for a couple of folders with references, and as you have stated, I haven't touched them, so.
And unless and until you have to look at them, let's not worry about it, because I don't want to spend the time having the lawyers go through to check to make sure that there isn't a sheet of paper that isn't in evidence or not in evidence.
Right.
That would take forever and doesn't help us along.
Right.
I think what she's got is her report material.
Exactly. I didn't realize I wasn't going to need it.
And So I guess the moral of the story is, unless you absolutely need to look at one of those items in your binder, let's not go there, because then
You got it.
adding tonnage to the number of items the clerk has to keep track of.
I don't really want to kill those trees.
Are we ready to bring in the jury? Mr. Hunter, are you ready for the jury? Let's bring them in. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that correct? Have you seen any media accounts since you were last with us? Has anyone approached you about this case since you were last with us? Mr. Anderson, you may continue. Before I did it, there's been a couple of references to Dr. Leslie Carroll. Obviously, my last name is Carroll. There's no family relationship between Dr. Leslie Carroll and myself.
Subject to redirect plaintiff yields to the jury's questions.
Well, it goes back to Mr. Hunter now.
Please go ahead. Counsel asked you about your access to the medical records when Dr. Tepa Sanchez called you.
Yes.
Was that as a result of your being asked to consult on a case by a fellow medical staff member?
Correct.
Is that customary, typical?
Yes, and
Objection, foundation, and predicate for that.
Well, the answer yes remains.
Your duties as the medical director of the Child Protection Team, the CPT, if we can
yes,
use that, the shorthand folks usually use.
that's the usual, yes.
Okay. Is part of your, do you understand part of your statutory duties with the CPT to follow patients who are sheltered under a child abuse investigation?
My understanding of my responsibility is to provide whatever assistance is requested from the investigators, law enforcement, and attorneys that are involved in the case. So I think I'll leave it there.
Okay. And I think I better leave it there. Have we ever spoken?
I believe, I might be wrong, I believe you were at one of my 5 depositions, but other than that, I knew of you when I worked at the hospital, but otherwise, no. To my recollection, no.
Have we ever discussed this case?
No.
Have you ever discussed this case with anyone from my office?
No.
Nothing further, Your Honor.
Mr. Anderson, anything further?
No, Your Honor.
Members of the jury. I think there's more coming.
questions, members of the jury, I'm just going to ask you to step out. Please do not discuss this case amongst yourselves. Do not do the investigation and receive no information.
All rise. Jurors exited. President Dr. Sally Smith, the
Dr. Smith, I'm going to ask you a few questions outside the presence of the jury. Okay. Have you had a conversation with a nurse, Bonnie Rice, from Tampa General Hospital?
Back in the time of this case, yes.
When was that conversation, to the best of your recollection?
Um,
And a month and a year is fine for
Oh.
purpose of this question.
I would say October into November, late October, early November 2016.
Was there any conversations, to the best of your recollection, between you and Bonnie Rice in calendar year 2015 about Maya Kowalski?
No.
Okay. I'm going to ask you those two questions first, and then I'm going to ask you the rest of the jury questions.
Okay.
Let's bring in the jury.
Yes. Jurors, enter it.
Okay, please be seated, members of the jury. I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct?
Correct.
That you haven't seen any media reports of this case, is that correct?
Correct.
No one approached you, is that correct? Outside of Dr. Smith's presence, I went through the jury's questions. I'm going to be able to ask a good number of them, but not all of them. Okay. Dr. Smith, have you had a conversation with a nurse, Bonnie Rice, from Tampa General Hospital in connection with Maya Kowalski?
She's a nurse practitioner, but yes.
When approximately was that conversation?
I'm pretty sure it was in late October, early November of 2016.
Have you had any conversations with nurse practitioner Rice in calendar year 2015 with respect to Maya Kowalski?
No.
Next question. Do you know why it is the hospital's policy to contact you first instead of reporting the suspected abuse to the child abuse hotline?
It's an unusual situation, and because of the way that the whole system is set up in Florida and they have to file a report for me to do a medical evaluation, sometimes they're not sure what to do. And so in those occasional situations, I'm going to say once or twice a year, a doctor from All Children's would call me to ask me a question about the case that they were involved in and request my expertise related to the child abuse and neglect question that they had.
Correct me if I am wrong. There is no harm in contacting the hotline prior to contacting an expert first.
I'm sorry, can you?
Sure. Correct me if I am wrong. There is no harm in contacting the hotline prior to contacting an expert first.
The only situation would be if there potentially wasn't really enough evidence or whatever to justify a report. So otherwise, no, I mean, typically the report gets made before I, as an expert, would be involved. Almost all the time.
How would CPT normally access the medical records?
So I always would access them through my remote access that's granted as a member of the active medical staff. If it was a child protection team, say from Sarasota County, that the person didn't have privileges at All Children's, then what they would have to do would be to, submit a request for the records to the hospital to obtain those records.
Does the county child protection team have access to medical records normally without privileges?
Only because, well, not like I do with it's an electronic access. Another team or somebody besides me would have to make that request. And there's statutory language that requires the hospital to provide those records in the furtherance of the investigation. So they can get them, but they can't just log in and see them as easily as I can.
Are the physicians that are part of the child protection team required to have privileges at a hospital to provide a medical assessment?
I'm pretty sure that is correct. So mine's easy because they're just the one hospital. Other teams, like say for example in Miami, I think the medical director probably has to have privileges at Jackson Memorial and Miami Children's in order to go in and see the child, but I'm honestly not sure because it's not my situation. So I don't know exactly what the rule is with that. I think probably they have to have privileges, but I'm not sure.
So if yes, do the privileges grant access to the patient's medical records?
Yes. So as part of our credentialing, we get re-credentialed every 2 years. We have to do like certain, HIPAA training about medical records. There are rules about which ones you can and can't access. And it's pretty closely watched and monitored. And so, I can do that in my role as the medical director of the child protection team, and on these occasional situations where they call me separately because they're not sure what to do and need child abuse pediatrician expertise, I can do it in that role as a member of the medical staff.
Is it standard for a child protection team physician to offer recommendation to a child's treating physician in a suspected child abuse case?
With regards to potentially certain tests or certain needs of the court, yes. So for example, if I'm seeing a child that has a bunch of injuries and they need a follow-up brain scan, I can make that recommendation to the team. Could you please do a brain scan on such and such date? And typically they're going to do what I ask them to do in terms of that, because it's something I need for the purposes of the investigation and to assist all the various people involved to make a good decision in the case. So I think that answers probably.
Who made the referral to your child protection team for the evaluation?
The child protective investigator called our person called a case coordinator that was on call or was the designated person to receive what they call intakes. So when there's an investigation that's been initiated, particularly in a case like this where there's a major medical component, then the child protective investigator calls the child protection team, and one of these case coordinators, or we actually had a person that they called an intake coordinator, takes the information, kind of reviews everything, and then that person would contact me and say, Dr. Smith, we need you to go down and see such and such child at the hospital.
When you told Dr. Dees to get Maya off as many meds as possible, did you know that was already in progress prior to telling Dr. Dees to do so?
I did not.
Do you still have medical privileges at Johns Hopkins All Children's Hospital?
Yes, I still have active medical staff privileges there.
Members of the jury, that is all the questions that I'm going to be able to ask. So, Mr. Hunter, you now have the floor, sir.
Could I have trial exhibit 2408-6? 1739 in evidence.
All right, what's the number again? 2408.
I've got 2408, what is that?
What's the second number?
You take that down, please?
$2408-1739.
Yes.
Yes.
Me- Okay, you lost me again. Wait a minute.
Also established the date and the time and what's
This is for your edification, Doctor, this is an email from Beata Kowalski dated 12 October 2016. And I'm going to ask that you go to page 1739, the following page. And then the midway through the second full paragraph on that page, there's a indications Tuesday 10/11 evening. I had another supersized visit from MD Dr. Smith, who was sent by CPS to investigate this case. Would that have been about the time that you spoke with Mrs. Kowalski, the author of this email?
Yes, that's exactly what, and she says an hour and a half, so just like I said earlier, that was that evening that I came down and talked with her.
Okay. There was reference to the EEG video that was taken of this patient.
Yes.
Have you ever reviewed it?
I don't believe so. It's possible at the time I looked at a few minutes of it, but I don't think so.
Were you aware of any indication on that video of Maya Kowalski defecating or urinating upon herself?
I had no idea if that was true or not, frankly.
Did you ever hear any indication of that and
No.
suggestion of that in real time?
No.
That's all I have. Thank you.
Mr. Anderson?
Yes, counsel, ask the court, make sure I'm asking the right question.
So no questions?
Yeah.
And Mr. Hunter, do you have any questions?
No, sir, Your Honor.
Do the jury have any further questions? Seeing none. Okay, members of the jury, I'm going to ask that you be back at 1:45, so just a couple extra minutes beyond our normal lunchtime. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. See you at 1:45.
All rise. Jurors exit.
The jury's out of our presence. Dr. Smith, there's a couple things we needed to do before we were able to break for lunch. So, Mr. Hunter, you have the floor.
Thank you, Your Honor. Scrounge up some clean copies of the reports here.
We're doing the proffer, just so you understand.
Okay.
Oh, Madam Court Reporter, if you could mark this transcript as the proffer.
Thank you, Your Honor.
Dr. Smith, this is a proffer for a potential appellate record, and what I'm going to do is ask you some kind of conclusory questions and some summary questions to avoid your having to sit here for a long afternoon, and all of us the same way.
Okay.
In the process of your investigation of the Maya Kowalski case, after it was referred to you, did you conduct an investigation? Did you gather some medical records?
I did a medical evaluation, including gathering a lot of medical records, yes.
Okay. And did you, in fact, promulgate 2 different reports
Yes.
regarding that? One was a preliminary report in October of 2016?
October 13th, correct.
Okay. And the other was one signed December 2nd, 2016?
Correct.
Do those reports both indicate the results of your investigation and review to that date?
Yes.
Okay. And in connection with your report in your investigation, did you obtain certain medical records regarding Maya Kowalski?
Yes.
And does your report, does the report you signed December 2nd, 2016, fairly and accurately reflect the records that you gathered and then reviewed for your report?
Up until that time, yes.
Okay. And then were there subsequent records you reviewed after that, after you received after that date?
Yes.
Okay. And does your report first of October, I think you said 13th, 2016?
Correct. Yes.
Does it fairly and accurately reflect your conclusions up to that date?
Yes.
Okay. And that would, if we were to walk through that report and what it was based upon, would your indication be that it contained and fairly reflected the outcome and your conclusions of your investigation up to October 13th, 2016?
Yes.
And would it also reflect what you advised, up to the conclusions and facts of which you advised the court, the dependency court, as of that date?
Yes.
Okay. And I'm going to show you what we're going to mark as whatever the court clerk tells me we're going to mark it as.
What's the next in the series for the defendants?
3328.
For ID?
For ID, it's not coming into evidence.
Correct. This is 3328 for identification. And let me just ask you, is that a true and correct copy of your report of October 13th, 2016?
Yes.
Can you hand that to me? Are you finished with it, Mr.
Yes, sir.
Hunter? Madam Clerk, it's two-sided, so just be careful.
And then after you rendered that report of 2006, these are new lips, I'm sorry, October 13th, 2016, after you rendered that report, did you continue an investigation as reflected in the report that you signed on December 2nd, 2016?
I continued my medical evaluation up to that point in December and gathered lots of additional records beyond what I had on October 13th, yes.
Okay. And I have a badly marked up copy of what I'm going to ask be marked for identification as defense exhibit.
Well, is there already a specific exhibit number on that? Down at the bottom, Mr. Hunter, the first page, look at the first page.
December or the October?
December.
The December is 3045, 1 through 46.
The answer to your question is my copy doesn't, but I trust Mr.
Mr. Hughes, will you stand up and let the clerk know what defense numbers are the two reports that have been previously marked?
So the first report is an October 13, 2016 preliminary report, and it is defense exhibit number 3044. The
For
December,
ID, it's not in, it's just ID.
just that for identification purposes. For identification purposes, Sally Smith's December 5th, 2016 report is defense exhibits number 3045, and that's pages 1 through 46, and it's currently being printed.
Or can't we just put the first
That's
page
that's
up
fine.
if you want?
That's fine. I apologize for that.
No, no worries. Thank you, Mr. Hughes.
And to the clerk for attempting to gum up the works one more time. Does your December 2nd, 2016 report, Defense Exhibit 3045, does it also reflect your opinions and conclusions as of that date regarding your investigation?
Regarding my medical evaluation, yes.
Okay. And just if you would briefly tell the court what your opinions were regarding this matter as reflected in that report.
As reflected in that report, it was my conclusion that there was what we call positive findings for medical child abuse, and that the medical record review and the history taking and that kind of thing that I had reviewed provided very strong evidence to support that conclusion.
Okay. Was there any conclusion, and is that the conclusion of medical child abuse would colloquially be known as Munchausen by proxy?
Yes, and I believe it's even in what we call the impression. That was my conclusion in the report. I put in parentheses Munchausen syndrome by proxy because that's kind of a well-known term for this situation.
Okay. And did you reach any conclusion regarding conversion disorder?
Yes.
And what was that?
It was my opinion based on all of the observations of the various medical staff and team and staff members, et cetera, as well as based on multiple other physicians' reports that I had reviewed that she had a conversion disorder. It's actually called a functional neurological disorder now, but at that time it was called a conversion disorder.
And when you say she, you refer to Maya Kowalski?
Maya Kowalski, yes.
Okay. In reaching the conclusions and opinions you've just expressed to us, how many pages of medical records did you review?
I don't know exactly as I sit here, but well over 2,000.
Okay. And I see you brought with you today a stack of 3, 4, and 5 inch binders that is on the table in front of you. Are those at least some of the records you reviewed?
Those are all of the medical records that I printed. So there were some that I reviewed in the electronic medical record from Johns Hopkins All Children's Hospital that I don't have copies of. But everything that I had a copy of in terms of all her medical records going back to actually her first visit to the pediatrician up in Chicago is in those binders.
Okay. And did the material you reviewed also include certain online WordPress blogs that had been created by Beata Kowalski?
Yes.
I believe that's all I have, Your Honor.
Mr. Anderson, do you have anything in Profer?
Dr. Smith, before, or let's say right at the start of this, in the first part of October, you had a call with Dr. Kirkpatrick, did you not?
I did.
And Dr. Kirkpatrick explained to you that he had been treating Maya Kowalski for CRPS, correct?
He did.
And he told you that statistically speaking, CRPS is often mistaken for conversion or Munchausen by proxy, did he not?
I don't really remember exactly what his words were. I took a few notes from the conversation that I had with him, and I know that there was some general discussion along those lines.
And yet you did not put anything in your report about Dr. Kirkpatrick, did you?
Yes, I believe there's a whole section about his medical records.
Yeah, except for the fact that you did not tell anyone in that report that he had warned you off of going after the Kowalskis.
It's completely irrelevant for a child protection team medical evaluation, because that's the whole point of the evaluation and gathering all the records. The problem in these cases is that the treating physicians have not done that. And so the fact that he, who sent her to Mexico for the ketamine coma, told me not to investigate child abuse, it was completely irrelevant to me, because my job was to investigate child abuse. So if I had come away from my job saying, I was supposed to do this, but this doctor told me not to, so I'm not doing it, and there's no evidence of anything here, I would not have been doing my job even remotely near a standard of care.
Do you not understand the importance of putting both sides of the story in your report?
The both sides of the story is the responsibility of the various people who are going to present it to the court. My job as the medical director for the child protection team is to do what I need to do to assist the investigators and the detectives and the attorneys that are involved in the case as to whether there is evidence to support a diagnosis of whatever type of child abuse is being assessed. So it's not my responsibility to lay out some whole long argument about what it might be otherwise if I have extensive evidence to support that it's a type of child abuse.
Dr. Smith, you know there wasn't a single child psychologist or child psychiatrist that diagnosed what you were claiming. You're aware of that, right?
That's also irrelevant.
So you are the ultimate decider of medical issues which you have minimal or no training in.
I have extensive training.
Yes, but
In-
you're not.
It's a Profer. You can answer, Dr. Smith.
I have extensive training in evaluating child abuse and neglect. Medical child abuse is a child abuse pediatric diagnosis. There is a parallel track in psychiatry where there's a thing called factitious disorder imposed on another, which is assessing the perpetrator or the caretaker in that scenario. But I don't need a psychiatric degree to assess medical child abuse. I'm very well trained to evaluate medical child abuse based on my child abuse pediatrics experience and board certification.
Well, there's not a single child psychologist or psychiatrist that agreed with you. You do realize that, don't you?
No, I don't.
Well, name a child psychologist or psychiatrist that examined Maya Kowalski who agrees with you.
Well, that wasn't their job to write in the report whether there's medical child abuse. So that specific thing documented by, for example, Dr. Cabot or Dr. Katzenstein, I don't know. Honestly, I'd have to look back to see if they ever documented that as one of their diagnoses. But that's not their job. My job is to assess that, and if I present adequate evidence to the court can act on that. So, the court has every ability to pull all these people in, including Dr. Kirkpatrick, including Dr. Hanna. I think they testified in the dependency action. And if the judge decides that there's serious question about whether I'm right, then, the court makes that decision based on the evidence that they receive. That's not my job to litigate the whole thing and put out all of the potential possibilities in the case and say, I'm the child abuse pediatrician, but I don't really know if there was child abuse here, because in this case, there clearly, in my opinion, was child abuse here.
Yeah. So you did not put in any of the conclusions or any of the data from Eagle's Wings and those therapists and psychologists that saw the Kowalskis, did you?
There was a licensed clinical social work intern who saw Maya and her family at Eagle's Wings, and I don't honestly know where that was in the pile of records when I was writing up my report. I kept writing part of the report, having to do other things, writing part of the report, having to do other things, and I inadvertently did not include that in my report.
Well, you did research it enough to realize that Rebecca Johnson had a master's degree and over 20 years of experience as a therapist at Eagle's Wings. Did you not?
Well, the question really, in terms of my part, is
I'm just asking you if you knew that or not, ma'am.
I knew she. I'd have to look and see exactly what her credentials were. I'd certainly, defer to you if you're reading her credentials off. But it's irrelevant unless she did the whole thing I did, looking at all these medical records, and has expertise in medical child abuse, for her to be able to say one way or the other if there was child abuse or not.
Okay. Look, did anybody agree with your assessment that there was no CRPS?
Yes, I believe they did.
Who?
I believe that there were multiple people on the hospitalist team that didn't think she had it, and I believe that although there was probably some question about whether she might have some sort of amplified pain disorder, the pain management team didn't think she had CRPS.
Well, amazingly enough, we did have Dr. Elliott in here to testify, and he never said that she did not have it. None of the doctors so far testified, A, that they were experts in CRPS, or B, that she did not have it. Are you aware of that?
No, I'm not. I wasn't supposed to watch any of the testimonies. I have no idea what people talk
gather
about.
that. From your investigation, though, at the time, did it come to your attention? Nowhere in any of the records did anyone who had any expertise in this, that is a pain management doctor, a neurologist, or a anesthesiologist, ever agree with your assessment that there was no CRPS?
I think I just answered that. Yes, I believe there were people that had the same opinion.
Okay. What did you check with Dr. Spiegel, a board-certified neurologist that treated Maya and confirmed CRPS?
Objection assumes facts, not in evidence.
Go ahead and answer.
Dr. Spiegel had this 10-year-old child do hyperbaric oxygen treatment, I believe, on 40 occasions in a row, when she also got ketamine on some of the same days. So I wasn't terribly worried about whether he thought or did not think that she had CRPS.
Because you'd already decided in your mind that a board-certified pediatrician with his years of experience was not qualified to render an opinion on that. Is that right?
Objection misrepresents the credentials and ask for comment on another, Crumville, another witness.
Go ahead and answer.
I'm sorry.
Dr. Barr,
Yeah.
a board-certified neurologist, he testified and confirmed CRPS. Did you put that in your report?
I don't know that I specifically said that he said that diagnosis. I think, as I recall, without going into the stack, that I did say in the history that Dr. Kirkpatrick had diagnosed her with that. Those people might have had that opinion. I don't think, based on my review of the CRPS literature and discussions with physicians since then, and in the context of all the evidence that there was of medical child abuse, that Dr. Barr's opinion, if that was his, that she had CRPS, was reliable.
Okay, so now Dr. Spiegel is not reliable, and he's a neurologist. At least will you agree that neurology and anesthesiology are the two areas that are most involved in the investigation of complex regional pain syndrome?
I imagine those are people that typically evaluate and treat patients with complex regional pain syndrome, sure. But not all neurologists and pain management or not all neurologists or anesthesiologists are, if you will, created equally. There are some who practice at a very high level, and when having reviewed medical records from all kinds of providers all over the state and even other parts of the country for 35 years, read through information and see all the supporting information that they have and compare that with other information that I gather in my medical record review, I can assess whether the person that, made thousands of dollars was reliable or not. And I didn't find those people to be particularly reliable in terms of their diagnosis, even though I certainly included their information in my report.
Dr. Hanna, an anesthesiologist with over 25 years of experience in treating CRPS, you didn't put his confirmation, he did a diagnosis of CRPS in your report either, did you?
I believe in the history. I made reference to that. I'm pretty sure I did say that he, made that diagnosis. But this is a doctor who was giving a 10-year-old child who was on the small side, 1,000 milligrams of ketamine, anywhere between 8 and 32 milligrams of Versed, doses of Zofran, 1,750 milligrams typically of magnesium, all at the same time in an outpatient setting with no documentation of vital signs, and there was indication in the records that appeared to me to suggest that the family member was the person monitoring the pulse oximeter. So that person, to me, is not particularly reliable in terms of whether this child needed the treatment that she was getting, whether he made an accurate diagnosis or not. So I put his information in my report. Yes, I discounted his diagnosis.
And of course, you discounted Dr. Cantu's confirmation of CRPS.
Well, I never got any records from Dr. Cantu, so I couldn't really address that whole situation other than from the WordPress blog. This person put a 9-year-old child in a ketamine coma for days. It took her probably about a week to just be able to be discharged from the hospital after that.
So
I didn't find him reliable from what I saw.
All right, so if I'm understanding you, the fact that 3 different treating anesthesiologists specializing in CRPS, 2 different neurologists specializing in the treating of CRPS, you know more. Fair?
I don't know more. As I said, I looked at their information, and based on what was done with this particular child, I did not find their opinion to be reliable.
And who elected you to be the judge of whether all of these board-certified physicians were reliable?
Nobody. I presented it to a real judge who made a determination.
Well, isn't it true, ma'am, that you are not a medical investigator? You are, in fact, a medical prosecutor.
That's absolute nonsense.
Because an investigator would include both sides of the story and let the judge decide, right?
No. The Child Protection Team medical director will assess whether there's medical evidence to support a diagnosis of child abuse, and then the dependency attorney will present that to the judge. And the other side gets attorneys also. There were 5 in this case. And they present all the information, and then the judge tries to decide you know, whose information is more reliable?
Here, under oath, are you telling us, are you an investigator or are you a prosecutor
I am
of
neither.
the information?
I'm a medical doctor who is an expert in child abuse pediatrics.
Mr. Anderson,
I
I'm
got
giving
it.
you very wide latitude.
I'm done.
You're finished?
Yep.
Okay. Mr. Hunter, anything further in Profer?
Very briefly, Your Honor.
When you spoke with Dr. Kirkpatrick and he warned you off, did he tell you that he had last seen this child 10 months before the conversation?
I honestly don't recall if I already knew that. I might have already known that.
And when you wrote your report, you had the Tampa General Hospital records, the Lurie Children's Hospital records, the All Children's records predating October of 2016, correct?
Correct.
You know, all those hospitalizations with all those specialists that saw this child, did you see any of them suggest that CRPS was the diagnosis?
No, and multiple were experts in complex regional pain syndrome.
Thank you.
Is the Profer complete?
Yes, sir.
Yes.
Okay, Madam Court Reporter, note that the Profer is now closed. Dr. Sally Smith, you had looked at a little report during your testimony. Can you hand that to
Yes.
me? I'm going to hand
And
it to the
you can
clerk.
keep it if you want.
Okay, I'm going to hand it to the clerk. Let's mark it as whatever the next number for plaintiff for ID purposes. And just tell us what that number is.
2804.
So the report that Dr. Smith looked at during her testimony in front of the jury is ID'd as 2804. It's not in evidence.
I'm sorry, I think you said in front of the jury. I think you meant not.
No, earlier during her testimony, she had pulled out a report, and that is what we just identified. Now, does Dr. Sally Smith, is she released or does she need to remain under subpoena?
She's released by plaintiff.
Released, Your Honor. You can watch them.
If you are released, you are no longer subject to the rule of sequestration.
Okay.
Thank you.
Thank you.
Okay, let's be back here, everybody, at 1:30. I will try to review Mr. Anderson's edits to the jury instruction. If you could let Mr. Altenburn and Mr. Elegant know that I'm going to try to address it at 1:30. Well, I'm just letting you know what my plan is. See you at 1:30.